Hello, everyone. What is a 601A waiver? Yesterday, we talked about possible consequences if you live in the US without a legal status and now you want to apply for your green card. They include being banned from entering the US and applying for re-entry for 3 or 10 years. So if you're worried about this, today we are going to talk about a way you may be able to avoid this ban, even if you have lived in the United States without a legal status. I'm Raluca Hanea. I work in the areas of immigration, estate planning, and family law for my clients. My marketing and office manager, Nina Clear, is here with me. And thank you so much for all your likes, shares, and comments as they help others to see our videos.
So what is the solution to not being banned?
You can apply for 601A waiver.
And can anyone apply for that?
Like anything else, you need to meet certain criteria.
And what is the criteria?
Okay, number one, you must be 17 years or older.
Okay, so you were brought here illegally as a child. Your parent could not apply for you if you're under 17.
No.
And what are the other requirements?
You must be physically present in the United States.
So you can't be here illegally, go back home to your home country, and then apply for the 601A waiver.
Not for 601A waiver. Every waiver has different requirements and instructions, and I highly recommend, if you have questions about a waiver and would like to see if one applies to your situation, that you meet with a qualified immigration attorney.
Why is that?
Because they will be able to review your case and let you know if you are eligible, first of all. Since there is a fee involved, if it would be best to consult with an attorney and determine if it is worthwhile paying the fee, which won't be refunded if you don't qualify for it.
And what is the cost?
As of today, which is May the 8th, 2019, it is $630. And if you're under age 79, you must pay a $85 biometric fee.
Are there any other requirements?
Yes. It seems like we have some, difficulties. Looks like our website doesn't work right, but I hope you can hear this. So yes, there are other requirements. You must be an eligible recipient of a certain visa, and you have to have paid the Department of State processing fee for that visa. And perhaps the most important, you need to believe you are or will be inadmissible because you had an unlawful presence of over 6 months for a single stay after you turn 18.
And that might bear repeating. You can't have traveled back and forth from the U.S., to your home country and back into the U.S. illegally. Your time where you had no legal status was just a single stay.
That's right.
Because I know you've had some people say, well, how would the government know it wasn't a single stay? So what's your response to them?
Well, with the information on social media and investigation, it is not difficult. It's not as difficult as people might think to find out if you have been here in the United States illegally before.
So we talked about the criteria to be eligible. Can you tell us if anything makes you ineligible to file a 601A?
Yes, there is a whole list, and I'm not going to list all the reasons, but a few that might apply most frequently are that you cannot be in deportation proceedings, have a deportation order, or a current grant of voluntary departure, nor can you have an I-485 pending with USCIS. And the most important is that you cannot establish that your U.S. citizen or green card holding spouse or parent would suffer extreme hardship.
And why is that important?
It requires a very high standard, and recently we have seen as immigration attorneys that even if with very strong proof, people are being denied when in the past they would not have been.
Okay. Do you know how long it takes to get a decision once you file your form?
USCIS says they are taking about 6 months, but remember their statistics don't include any cases that have RFEs, the request for evidence, sent out to the applicant. So I would suggest it is longer than the 6 months, then because we don't have the actual statistics.
And what about if you do get an RFE? Do you know how long it takes after you answer that?
Well, it can be a month or 2, 4 months after you send in the evidence that was requested.
Okay, and one thing that many people are confused about is they think I have young children in the U.S. and having to leave them will be a hardship, but they don't really look at that, do they?
It can be considered as part of your circumstances, but the most important is the impact the separation will have on your spouse or parent being affected by the extreme hardship, not your children.
Can you give us an idea of what extreme hardship is?
They look at several categories: health, finances, education, personal and special considerations. The most important thing here is that the applicant must prove more than normal hardship due to the separation.
And you yourself has successfully submitted 601 applications for clients, and they've gotten a positive response, right?
Yes, I have.
Sometimes the USCIS, whoever makes the determination for the 601 waiver, also considers if the country they come from is dangerous, right?
Yes, again, they look at what in the legal field is called the totality of circumstances. So they will look at if the Department of State has issued a warning about traveling to or living in a country due to safety concerns.
And once the waiver is approved, what happens?
Then you must travel to your country of origin for your interview.
And if you're granted the waiver, it doesn't give you any type of legal status to stay in the United States, does it?
No, if you are here illegally, even if you have the waiver, you are still here illegally. And I want to make clear that this is a provisional waiver. That means that even if you are granted this waiver, it does not mean you are granted your green card.
And if it is denied, if the waiver application is denied, can you appeal that?
No.
Can you file for another one?
Yes, but you must submit a new fee and evidence and still be eligible for it.
Which sounds like it might be difficult because you've left the U.S. If you've left the U.S. for the waiver. So you might not have. You might have been denied. But if you left for the interview, but then you won't be allowed back in because you can only file it if you're here in the U.S., right?
That's right. And people should keep in mind that a provisional unlawful presence waiver is automatically revoked if the alien at any time before or after the approval of the provisional unlawful presence waiver or before the immigrant visa is issued re-enters or attempts to re-enter the United States without being admitted or paroled.
So if someone was given a waiver, but they hadn't yet gotten the green card or the visa, and then they came back into the U.S. illegally, the approval is null and void.
That's right. And I hope this gives some hope if you're worried about your unlawful presence. There is a way to overcome that, and we can help you to get back on the path to citizenship. So please let us know if you have any questions, as we are always here to help. And thank you again for all your likes and comments. See you soon.